Good afternoon. My name is Ksenia Bistolkova, and today I'm going to be walking you through standard ocean carriage liability for damaged screens and a cargo coverage under SCALD policy. So the order of the presentation: first of all, summary of the facts. Then I will walk you through maritime law part, legal questions, rule, legal analysis, conclusion, and space for any questions if you have any. And then for the insurance law, we'll cover legal questions, rule, analysis, conclusions, and space for any questions if you have. So go into the summary of the facts. Screen time. Conseni and a buyer ordered 20 large screens from Large Venue Video, who is a shipper and a seller. Large Venue Video specializes on designing large video screens, and the company is known for its high quality, while Screen Time is the company that provides these video systems for large conferences in the US. When the shipment with the screens arrived at the port in Miami of the US, Screen Time has rejected the screens, stating the product's appearance and the function seem to be damaged. Now a shipper is bringing a claim against the carrier as for the purchase price of the product and consequential damages. In its claim, the shipper says that a cargo above deck was a quasi-deviation. Moreover, the carrier Standard Ocean Carriage is a member of Scorpion Club and has coverage through SCALD. However, SCALD states it may not cover the claim, saying it is for deviation. Cargo was carried on deck and had issued a reservation rights letter. So parties in the case: carrier Standard Ocean Carriage, shipper, seller Large Venue Video, and consignee by Screen Time, and then also insurer SCALD P&I Club. So the legal question: maritime law. What is standard ocean carriage liability as a carrier for the large venue video screens damaged during transportation in accordance with Bill of Lading, the Carriage of Goods by Sea Act, and a concept of deviation under US maritime case law? So rules apply of COGSA Section 4, there is no infringement if the deviation is reasonable, so to save the property. However, if the deviation arose from stowage, it's unreasonable prima facie. And then Section 5 says that there is no liability if damages related to the carriage of cargo above $500 per unit, unless priorly included in Bill of Lading. Bill of Lading does not specify the value of the goods. Cargo shall be shipped below deck, and just says that cargo shall be shipped below deck, contains no declaration of value and DPU. And then there is some case law, General Electric, saying that the deviation that resulted in the increase of risk of cargo damage was found unreasonable because Bill of Lading agreed on shipping below deck, and the carriage solely chose to load cargo above deck. In result, the cargo exposure to the weather condition and sea got higher. And then some GSA definitions, and another case law of Mitsui Fire, which stated that false BOL constitutes a quasi-deviation, and the court prohibited to invoke SOX limitation of $500 per package, and establish that the carrier is liable. So there is interconnection Bill of Lading, the carrier's duties and liabilities incorporates COGSA. COGSA just defines contract of carriage, other like deviations and liabilities, and deviation principle is just a fundamental breach occurs by deviation, then the monetary limit established is inapplicable, and a false statement in the Bill of Lading. And then analysis that stowage by the carrier of the cargo above deck without agreement when the Bill of Lading considered below deck is deviation, then it's unreasonable prima facie because it was for the purpose of stowage. And then since the carrier solely decided to put the cargo above deck, knowing about a high risk, the limit of $500 per unit is unapplicable, and therefore the carrier is liable for the damages. Conclusion: there is unauthorized stowage and unreasonable deviation. It's excluded from exclusion of liability is unapplicable, and therefore the carrier is liable. So the next question is, to what extent does Scald insurance policy provide coverage for the damaged cargo during transportation under the policy? And what types of dispute resolutions of the dispute concerning coverage of the damaged cargo available in Scald and Standard Ocean to Standard Ocean carriages? So Rule 511 applies with the foreground and trigger, and then some relevant limitations, which says that it excludes coverage of carriage on board unless one of the conditions is met. For example, it's suitable to carry, there is a contractual liberty, and bill of lading is tailored to notify that the cargo is on the desk. And then 5 to 11 excludes cover for the deviation unless agreed previously with association, and requires in 544 additional cover if the carrier wants to cover unauthorized stowage, for example, or carry on deck. And 47.1, just dispute resolution through arbitration. Insurance laws. So exists, grant and trigger exist. Limitations apply since one of the conditions is not met because it's not suitable for carriage on deck. Moreover, there is no additional cargo cover and the goods purchased that would compensate for unauthorized cargo, and therefore there will be no compensation. So, and just a dispute resolution through arbitration in Oslo that will be governed under Norwegian law with no, because there was no prior agreement otherwise. And conclusion is there is no compensation under Scald P&I coverage since the damage resulted from the unauthorized carriage on the deck, specifically excluded. The conditions for exclusion to be covered are not met, not suitable for deck carriage, and no additional cargo cover. Dispute can be resolved through arbitration. Do you have any questions? Here's some footnotes. Thank you for your time, and I'm open for any further questions.